So, discussing CPSE, we're going to talk about the orientation and strategies that you can use. There are 4 primary content areas, and this audio presentation that we'll be talking about is on the legal and ethical standards that guide our practice as psychologists. Legal and ethical standards comprises about 39% of the test, though it might be more on this current version in May of 2015. The area assesses your ability to not only know the law and ethics, but also apply them to current professional standards in clinical practice. So let's dive into Ethics Street and Law Way. So if you had the PowerPoint picture presentation, that's what you would see. So before we talk about the actual laws and regulations, the most important thing, really one of the most important things anyway, is knowing how to process the law and ethics questions on the test. So you're going to see a vignette. Okay, this might be true for some of the other questions too, but in the law and ethics, there's going to be some sort of vignette, and you're going to have to apply these rules. So highlight the relevant information in that vignette. Ask yourself, what are the things I need to know here? Is there an identifiable victim? Might be one of those things you need to know. And you can even take a moment right now. You can hit pause if you want, and ask yourself, what are the questions that are relevant? What is relevant information? What are some questions that, as you go into the test, you want to have in your mind? For example, identifiable victim is one question that would relate to Tarasov. Another example is, what is the age of this client, right? Like, are they a minor or not? When you are assessing for 1024s, you don't have to be a danger to you don't have to have a threat of severe physical violence to an identifiable victim, but you do have to be a danger to yourself or others. So differentiating between Tarasov and danger to others with the 1024 is also important. So once you've highlighted some important information, look at that and say, okay, what do I know? What have I learned about in terms of law and ethics that is very pertinent here? What is the issue that is, or what issues, plural, does this really bring up? So if it's about a minor and you have bruises on their arms, right, you know that you're getting into the realm of child abuse reporting. So really name that for yourself. You can even write it down on your cheat, or your, not cheat sheet, but the piece of paper they give you. So you've highlighted the relevant information. You've identified whether it's pertinent. Now, actually, this is before you look at the answer choices. Paraphrase for yourself any legal or ethical limitations or requirements that you know of off the top of your head. Hopefully that's easily accessible off the top of your head because you've studied thoroughly. So you might say, okay, well, legal and ethical standards for child abuse and child abuse reporting are that I am a mandated reporter in the state of California. So I am required to, so there's a requirement. I am required to report if there's a, reasonable suspicion. So that's the third. And then fourth, now that you have a sense of the legal ethical limitations requirements, what's the issue, and what the relevant information is, you can now move on to saying reading through the answers, and you can do what you usually do, which is the plus, the minus, or the maybe. So going through and reading them with in mind what you had already kind of come to understand. And then you are going to eventually, hopefully not taking too much time, choose. Okay, so as we delve into the knowledge that will be needed on law and ethics on the exam, we're going to talk about legal and ethical decision making. So law and ethics are related but not the same, and sometimes they can be at odds. So I think, think for yourself an example. It doesn't have to be psychologist related of when law and ethics come into conflict for you, and how you in your personal life, let's make it not a clinical issue, how you navigate that conflict. Okay, now stepping into your professional role, what, as a licensed clinical psychologist, in what way are you expected to navigate these things? You can be a rat in your personal life, as Sharon Jablon likes to say. And if your way of dealing with it is screw law and ethics, then that's fine in your personal life, as long as you don't get like a felony or anything else that relates to your practice. But in your professional life, the language is always clarify the nature of the conflict, make known commitment to ethics code, take reasonable steps to resolve. It says that if the ethics code establishes a higher standard of conduct than required by law, then you want to meet that higher standard, even if that is not enforceable, strictly enforceable by law. It can still be used in cases if you are in violation of the ethics code, and certainly can be used by the board. When you consider state or federal law or the ethics code, make sure you're clear what it's asking about. So there might be things on the exam. So there might be things that relate to both the law and ethics code, and you want to look for the higher standard in terms of law. So that's the gist of. We're also going to talk about HIPAA, which is the Health Insurance Portability and Accountability Act. Way to sound boring. But this is important because we now live in this world of technology and electronic communication. And so there's been a lot done around how to protect health information, particularly now that it can be transmitted electronically. 3 things you want to know about. First of all, know about how to answer the questions that relate to HIPAA, anything specific that can help you find the right answer. And then there's also different rules. There's the privacy rule and the security and transaction rules. A practitioner falls under HIPAA if there has ever, even once, been any significant electronic communication with patients that includes patient info. So you send one, one email to an insurance company or something, you need to know these standards because you need to be abiding by them. California law and HIPAA. The 3 rules: privacy, transaction, and security. There are 3 rules to HIPAA. The privacy rule regulates and safeguards regarding confidential patient information. The transaction rule standardized electronic transmissions. And the security rule addresses physical security of patient records, like locking filing cabinets. When it comes to HIPAA or state law, whatever provides either greater privacy protection to the client or greater access to the client for their health information. Who must comply? Well, you can look at this chart, but the moral of the story is if they are a healthcare provider that uses electronic communication. Protected health information. We need to distinguish between that and psychotherapy notes. PHI is something that identifies a patient. It's transmitted in any form, and it includes their condition, their services, and their payments. Some examples of what would make something PHI. And then what about the privacy rule? This is the big one. This is what protects their information. It requires providers to inform them of their policies, grant clients access,
obtain authorizations before sharing non-routinely, securing their records, informing people, business associates of privacy practices, and training employees about privacy procedures as well. So what about accessing your healthcare information? Well, you, as a client, you have the right to have access to it yourself. And if you are denied, there's two different standards with HIPAA and California law. HIPAA says that you have a right to review the denial if they denied it because it said it was reasonably likely to endanger the life or physical safety of someone. However, they say they don't have the right if it's because it's something that's exempt from right of access, like it's compiled for use in a criminal case. HIPAA permits but does not require them to maintain their two sets of records. With HIPAA, clients don't have the right to review therapy notes, but California law rules here, and psychologists may, upon request, provide the client with a copy of their notes. Authorization to disclose. There's two things, generalized consent and authorization. Generalized consent is basically anything of what they call TPO, is you don't need to actually get formal consent if it's in the for the purpose of treatment, payment, or healthcare operations. However, information released to anyone that is not related to their healthcare, like an employer or school, does need their consent. Clients have a right to the notice of privacy practices and to have it explained to them in reasonably understandable language. What are the minimum necessary standards? And finally, what about patient rights that are in HIPAA? You have right of notice, knowing the privacy policy, right to request restrictions of use of your information, right to get information with phone calls and bills and to whatever address you want, have right to inspect your records unless it would jeopardize someone's safety, right to request changes to your record. Of course, you can say no if they're asking you to say something inaccurate, and then right to receive an accounting of everything over the past 6 years. And what about the security and transaction rules? These are going over electronic transmission safety and the security of patient files. Okay, competence is also important. Psychologists are legally and ethically obligated to practice within the scope of their competence. We'll talk about that in terms of unprofessional conduct, emergencies, personal problems, delegating work to others, and also what happens when you want to explore a new kind of area. Okay, so California Code 1396 says a psychologist shall not function outside their particular field of competence as established by their education, training, and experience. Further, the board may refuse to issue any registration or license or can suspend or revoke if they found a person has been guilty of unprofessional conduct. So there's the California Code and Board. In terms of the Ethics Code, ethically you must provide services only within boundaries of competence. If there's an emergency, you can provide services until someone else shows up who is more competent and the emergency is over or the emergency was over. Finally, we are legally and ethically obligated to take appropriate actions when personal problems might interfere with the ability to provide effective services. A couple other notes about boundaries of competence. If you delegate work to other people, you are still obligated to that they are able to perform the duties competently and make sure there are no harmful multiple relationships there. And if you want to go into a new area of your practice, you actually are allowed to do that, but it's important that you consult, get further training, I mean, you have to get new supervision for something completely outside. But if you have close and no one else in the town can provide those services, then you can get some more training experience and consult and provide them.
Okay, we're now going to talk about confidentiality and privilege. This is a big theme as a psychologist, so you'll hear more about this in other sections, but first let's just do the broad and basic overview, really key concepts. So we have both confidentiality and privilege that are related and different issues. So we're going to go into the definitions of both. In addition to the definition, I want to talk about ethical requirements and also the legal requirements. So this is the law and ethics section, which means that there are both things you need to do ethically, but there's also the legal piece. So how do we define confidentiality? Let's start there. It's the patient's right to have communication kept within the bounds of the professional patient-therapist relationship, generally not revealed to third parties. So anyone outside the professional relationship would be revealing it. And any of this information could be from like examining them or anything else that happens during the course of the professional relationship. It is legal and ethical to maintain confidentiality. Interestingly enough, when it comes to confidentiality, you must give confidentiality to the public. 100% we must give confidentiality to the public. So if you want to spend a little time, you can pause and think about what does that mean? What's an example where the public would need confidentiality? Okay, so let's talk about the legal aspect of confidentiality. And there's two primary laws to know about, and that's the Lantrum and Petrus Short Act, LPSA, and the Confidentiality of Medical Information Act, CMIA. So, two California laws is the Lantrum and Petrus Short Act, and that's saying that mental health information for patients that are in a public system or hospitalized in a psychiatric facility is a little bit different. And Confidentiality of Medical Information Act is a California civil code, and that applies to all mental health professionals.
Okay, so now let's talk about when we can breach confidentiality. In situations of threat of serious physical violence, if the client, it's a 1024, if you have reasonable belief that a client is a danger to themselves. If a minor is abused, an elder is abused, if a court orders it, and the Patriot Act finally as well.
So to define privilege is pretty simple. It's just the patient's right, legal right, to refuse to disclose and to prevent another from disclosing confidential communication in a legal proceeding.
Okay, so privilege is a legal term, and this refers to the person's right not to have confidential information revealed in a legal proceeding. The holder of the privilege is the patient when they have no guardian or conservator. It can also be the guardian, or if they're dead, a personal representative that's been appointed. And let's talk about the exceptions to privilege. Privilege does not apply, of course, when the client authorizes a release of information or when the psychologist is legally mandated, for example, abuse. Again, as well, the client, if they disclose a significant part of the information to a third party, it's no longer privileged information that the therapist can't discuss. And finally, there are some legally defined exceptions, and there are 9 of those. Someone's in a court case raising the concern of an emotional condition, they open up their file. If the therapist is appointed by the court to evaluate, there isn't privilege, but you need to let the defendant know that. The board of prison terms might appoint someone to evaluate if they need mental health treatment. Again, there's no privilege there, but you want to let them know. Crime or tort. Now, if a client runs into your office to try to escape the police, this you're aiding them in committing a crime, and you are not required to. There is no privilege there. It's not even about holding privilege. There's no privilege then. Breach of duty out of the relationship, no privilege. No privilege with determining sanity of a defendant. No privilege when someone is a danger to themselves or others. That's 1024, not Tarasoff, 1024. And finally, two more things. If it's a proceeding to establish their competence, or if they are under 16 and they were a victim of crime, there's no privilege there, though it doesn't have to be reported. It's up to what's the best interest of the client. So these are the different so 3 different people can hold privilege. With minors, it's a little bit of a complicated issue because according to kind of in the country, it's the guardians considered the holders. But in California, we say that minors themselves have privilege, but even though the adults will typically claim or waive it for them. Parents don't have access with emancipated minors, of course. And if you're a ward of the state and you're over 12 and mature, then the kid has the privileges for sure.
Okay, so we know that privilege is held by either the patient, their guardian, or their personal representative if they're deceased. But the question now is, who can claim it? And that it can, not in addition to the holder of privilege, it can be claimed by another authorized person, such as the therapist, and the psychotherapist is able to claim privilege in any of those particular communications that happen within the therapy. Only the holder of privilege can authorize a waiver of their privilege. No one else can do that. When more than one patient holds the privilege, like couples therapy, one patient waiving privilege does not affect the other patient's right to claim privilege. Privilege is waived, however, anytime a confidential communication is disclosed by the patient to unauthorized third persons. For example, if a patient tells his neighbor he raped a woman, and he shared that that he has shared this with his therapist, that information is not privileged anymore because he has made that public. The therapist is generally required to claim privilege. And I should just say that, so in court, the therapist could acknowledge that that statement was made to the neighbor, especially if it's not in dispute, but they can't add other details in that weren't shared. So it's not like, oh, it's fair game now. The psychotherapist is pretty much required to claim privilege when that the communication between them is sought. But if there's no holder of privilege in existence, then you cannot do it. I don't know when that would be, so if you want to just take a minute to think of when is there no holder of privilege, or if you're instructed by a person authorized to permit disclosure, which could be the patient or it could be someone else. Yeah, but the client always holds the privilege, not the therapist. You claim the privilege, you don't hold it. So, let's go over all the exceptions to privilege and try to do so in a way that it can be remembered, actually. And now this slide that we're looking at, if you were looking at the slides, doesn't have the numbers attached. So let's just get the concept down, and then if you want to go back to the numbers, we can do that as well. But so the question here is, when can the judge say, you know what, there's no privilege here in a legal proceeding? So let's start there. Let's start with if it has to do with the court. Okay, so in a courtroom, there are a number of codes that have to do with communication between a therapist and the, patient, or at least person who's being examined. That could be to examine them. The court's asked for them to be examined. The defendant has asked to have their sanity determined, perhaps the patient saying, I'm not competent to stand trial, so, um, or they're just trying to see if this person's competent. So in all of these cases that are about determining the criminal defendant's state of mind, information is not privileged, with one exception, which is if it's the court has ordered it specifically to provide the defendant's lawyer with information to help the defense. That's the exception. Now let's move to another issue in which it would come up in a sort of court related event, which is if someone has instigated proceedings where they're claiming that someone has caused them emotional or mental harm, so like a workers' compensation suit. They're claiming emotional suffering, their therapy records are no longer privileged. So that's another legal proceeding issue. A third-ish legal proceeding issue has to do with crime. So if the therapist was sought out because they had just robbed a bank and then they decided to schedule their therapy appointment because, like, oh, then my therapist can't reveal that I wasn't there or something like that, then that is not protected either. So if the therapy was sought to aid or get away with some sort of crime, patient cannot invoke privilege to hide that. What else? So there's other issues that might come up would be, well, final court issue would be a breach of duty. So if the therapist or the patient, if somebody is alleging that there's been a breach of duty, so basically a malpractice suit that was initiated by the patient or like a collection agency of the therapist, so like somebody hasn't upheld their end of the therapist-patient deal, then that is also a case in which there is not privilege. Okay, so I do think that covers it with the court. So can you just say to yourself briefly, what are the different legal proceedings in which there is no privilege? Okay, so with the court itself, it would be examining the emotional and mental state of the patient. With breach of duty suits or suits that have to do with emotional conditions or suits that where the therapy session was somehow aiding a crime, these are lawsuits where it does not apply either. So now we get into basically danger to the self, other, or property, and crime victims. So 1024 is a huge one to know, and that is that the therapist, there's not privilege when the therapist believes that specifically their mental and emotional condition is causing that person to be a danger to themselves, to someone else, or to property of others, not their own. And the disclosure is necessary to prevent the danger. So there is not privilege. Now, it might not be a mandated report in the way Tarasoff is, but this is really the code that says we can report things besides Tarasoff, where there's an identifiable victim who has been threatened, their serious physical life danger. This is the code where we can really break confidentiality to protect. It's 1024. And just remember that it has to be a result of their emotional or mental condition. They have to be a danger, and the disclosure has to be necessary. So there's not something else you could have done to prevent the danger, like, I don't know, whatever that might be. You could try to think of an example for fun. And then minor crime victims. So if a patient's under 16, so if you're working with a kid and you think they were the victim of a crime, then there is not privilege either. And the parents and the kid, even the parents or guardians cannot invoke privilege as well. It's really about what the therapist thinks is in the best interest of the minor. So there's a difference between required to report and a situation in which you can report, and you need to, of course, think about what the most ethical path for you as a therapist. And now, if you were to ask yourself what's missing, can you think of what we have missed in terms of exceptions to privilege? Okay. Two other things. One is when you have a deceased client, what happens there? And two, what happens when something has been stated publicly already by your client? So these are exceptions as well. Now, just because someone's deceased does not mean there's no privilege. But as it relates to an issue where there are people, there is dispute over property and claims of that patient, then there is not privilege around the therapist stating the validity of this, of things that relate to this issue. So whether it's the validity of the deed or will, or whether it's what the client really wanted when they were alive, there's no privilege here when it comes to that. Now that doesn't, of course you're going to limit, doesn't mean everything is, it's not a free-for-all. You don't get to talk about their, feelings toward their sister after they turned 12 or something, but there, when it comes to the money and property issues there, and there's a legal dispute, there's no privilege for that deceased person. And then, I don't remember if I just said this or not, but a public report. So if a patient said something publicly, the report's open to public inspection, then a report made by a therapist that's open to public inspection is not privileged. So, if that makes sense. So those are the main codes. So let's just go over the numbers for the codes really quickly. So they're all, it ranges from 1016 to 1027. These are the privilege exemption codes. And 1024 is the patient's dangerous to self or others, and that's going to be the most important one to remember in all likelihood. But let's go from 1016. The patient litigant exception is 1016. That means that if the patient's suing for emotional suffering. 1017 and A and B are basically that if it's a board of prison or court-appointed therapist, no privilege. 1018, if there is a crime involved, no privilege. 1020, if there's a breach of duty in the relationship, no privilege. 1023, proceedings to determine sanity, no privilege. 1024, the big one, patients of danger to self or others. 1025, a proceeding to establish competence, no privilege. And 1027, the patient under 16 is a victim of crime. And 1026 is the one about the public. So those are your exemption codes. So you probably don't need to know that, but if it helps you to remember, there they are.
If a client is suing an airline company, for example, for emotional distress, that opens them up to their therapy records becoming completely public. You must tell someone when you're determining their competence or sanity that they don't have any confidentiality, so that has to be clear. Board of prison terms, that would be just about, do they need treatment? And actually, if we are a victim of crime, we may also break, in this case, we can break confidentiality. So that's actually about confidentiality, not privilege, but we can break it in that circumstance. All right, we're going to talk about legal and ethical decision making, particularly management issues in therapy. You're required to give both the notice to consumers and the notice of privacy practices to your clients. Well, actually, notice to consumers just needs to be hung, and privacy practice must be given to them and placed prominently. So what about informed consent? This is addressed predominantly in the ethical standards, with one exception being the telehealth. And you will find this in the ethics code primarily. So when you want to provide informed consent, for informed consent is what it is if it's someone who's capable of understanding, if they do not If they're minor or they can't understand, you can seek assent, which is a little bit different. What are the conditions for informed consent? There must be the capacity to make rational decisions, the comprehension, so you need to provide reasonably understandable language, and voluntariness. They cannot be coerced. So the only legal requirement to really know about is that for telehealth, which is when it's delivered via technology, there needs to be verbal consent, and you need to document that. So the ethics codes that address this are 310, 1001, and 903. So we'll talk a little bit more about that. For people who are legally incapable, seek their assent. If you're conducting any sort of research or assessment therapy, any professional activity, you must obtain informed consent unless there's a mandation, you're mandated by law or regulation. Not that you don't need to or shouldn't. Court-ordered services must provide informed consent. Inform them. I mean, it's kind of court-ordered, but they must be explained the limits of confidentiality. And just always make sure that you document it no matter what. This should be in the file. In terms of third-party requests for services, this might have to do with parents and kids or court-ordered evaluations. Need to be really clear of who the client is, even if there's not a simple answer, and clarify these things with the different parties. What are the confidentiality limits? Like with an employer, you need to say, hey, I'll give you the information that's relevant to the evaluation, but not all of the information is open to you, like about their marriage or something. Okay, so we're going to talk more about client records, and I want to give a brief overview of, well, actually really everything you need to know in one short presentation. First of all, how you maintain your records is essential. How the inspection and copying of your records is essential to know about. And along those lines, you need to know how to respond to clients' requests for access to their records, which could be the time frame, for example. So in terms of maintaining records, you want to know the time frame, the content, and electronic issues. In terms of the inspection and copying of records, you want to know about parental access. You want to know about patients' rights and when you can deny them. You want to know about, and then you want to know about the different timing for inspection, copies, and summaries of treatments. Finally, know a little bit about psychotherapy notes and the difference there. Let's start with the first question is, who owns the record? Actually, your client owns the record, so that's important. You own the physical, you are the keeper of that physical file, but you're more of the custodian. What else? Parents and guardians have a legal right to inspect and obtain copies of the minor's records. All that matters is that they have the legal custody. They can, if there's possible detrimental effects, in California law, the therapist can deny. If the minor authorized themselves for treatment, then you can deny the records or the access of the parents. So who owns the record of a client? Well, actually, the client is the one who owns it. However, the psychologist owns the physical or electronic document. We are responsible ethically for maintaining records. This is addressed in number 601. This is also true with research studies. We must also maintain confidentiality of these records and dispose of them properly, as well as plan on what to do if we ever die. We need to have a plan in place. When we're talking about the time frame for treatment records,
we are in the realm of the health and safety code. And when it all comes down to it, we in California need to keep records of minors until they're 25 years old, because the basic law is we need to keep full records on our patients 7 years after treatment has been completed, and for minors that just means 18. So California, it's 25. Now, if it was not California with APA, it's just 3 years. So it could be 21 or a total of 7, but California law supersedes. So just know the APA guidelines, but that's not as important. Okay, so in terms of electronic record keeping, we're talking about how to keep things safe and secure. So here's what you need to do. Have an off-site backup storage system, an image mechanism that can copy signature documents, and finally a mechanism to ensure that once input, the record is unalterable. So original hard copies, if you have this really in place correctly, you can destroy the original copies and just keep the electronic. Furthermore, just make sure there's policies and procedures that will safeguard confidentiality and deny unauthorized access, and that you are in keeping with all HIPAA policies. The guidelines, if you are keeping hard copies, the guidelines on this don't apply in terms of the stringent, because you actually do have your hard copies. But if you don't, then you need to comply. Printout shall be considered the original for purposes of giving to client in court. So if you do get rid of hard copies and you print it out, that's fine. This does not exempt licensed facilities, though, from keeping original records that cannot be stored electronically. And yeah, you might want to just do some research. This could be one interesting thing to do if you have spare time, or if you end up getting into this, is what are the safeguards that are necessary? What is an electronic signature key? What is system maintenance? What are the details? What platforms do people use? So HIPAA really wants you to safeguard people's information, but you are allowed to do electronic record keeping.
Most important here is the client has access to records. Of course, there's always exceptions. And those exceptions are different when it comes to HIPAA and California law. In some cases, HIPAA preempts, in some cases, California does. So similar to HIPAA's privacy rule, California laws are pretty similar to this. So let's see. Let's first talk about when you can deny a client. Okay, when can you deny a client? Well, when having access would reasonably be likely to endanger the life or physical safety of the client or another person. That's HIPAA. However, in California, it doesn't have to be that extreme. It's that there's a substantial risk of adverse consequences. Now, so in this case, you have to follow HIPAA because this gives the client more access. In terms of psychotherapy notes, California wins because while HIPAA says you absolutely can't have access to your psychotherapy notes, California says actually you may give them a summary or the actual note if you want. In California, it says you have to present healthcare providers with a written request for records, which is consistent with HIPAA as long as clients are informed of this. And finally, can you withhold records because of unpaid bills? No.
Adult patients, parent guardians of minors in treatment, minor patients, really, and patient representatives, they're all entitled to inspect and obtain a copy of their own records after they present a written request. Psychologists cannot withhold patient records or summaries. So, on the basis of an unpaid bill. So, what about parental rights to access treatment records? They have a right to do so, contrary to what many psychologists of teens would want. But in a situation where the parents are divorced, this right even applies to a parent who doesn't have physical custody. So it really doesn't matter who's living with who, as long as it's a legal guardian, they have their rights. There are two circumstances where they can be denied. first of all, if the minor came into treatment and was legally authorized without their parent, um, then the parent had never really given the consent and doesn't hold the privilege there in the first place. Secondly, and this is in California, and because California law is more stringent, it supersedes any others. But if it could be a detrimental effect on the therapy relationship or the minor's physical, emotional well-being could be jeopardized, the parent can then also deny access to the treatment record to the parents.
So what happens when a client requests the record? Well, there's a time frame for responding, and that's important to be aware of. If you have a longer record, it can be extended to a month, and there's different time frames, whether it's being copied or summarized. Okay, so we're going to talk about multiple relationships and conflicts of interest. So let's define a multiple relationship. Well, multiple relationship is basically saying that you are in two roles with a person. It might be with that person specifically. You could be in a relationship with someone closely related to them, or promising to enter a future relationship. All of these three things. Multiple relationships are addressed in the ethics code. So this isn't a legal issue in particular as much as it is an ethical issue. Multiple relationships are not inherently unethical. There's two conditions to meet for them to be acceptable. They must not impair objectivity, competence, or effectiveness, and they must not harm or exploit the other party. If something does occur and a multiple relationship arises, it is the psychologist's duty to resolve it with due regard for the best interests of the affected person and maximal compliance with the ethics code. So that is what you are supposed to do. Here's more on multiple relationships. Just to be careful and mostly just no harm. What about forensic settings? There's two things to consider here. The first is if you're legally required to do it, if it's not avoidable, make sure you clarify role expectations and any confidentiality issues. Now, secondly, let's say that you've been asked to, then try not to, but make reasonable efforts to refer. But if that's not feasible, you can do it. Just disclose risk, consider risks and benefits of all parties, and basically you're just trying to minimize any negative effects of the circumstance. A little more on forensic psychology. Multiple relationships do come up, so really trying not to provide concurrent services, but if you do, you do. Conflict of interest. Most importantly, you don't want multiple relationships to bring up a conflict of interest. So if you're teaching and you're grading and you're the person's therapist, it presents a conflict of interest. Gottlieb recommends the three different aspects to multiple relationships and how to determine if it's not ethical. If it's long, if there's a strong power differential, and how far in the past that relationship really is. Is it really not therapeutic anymore? It's fees and financial relationships, important to think about referrals, bartering, and ethical guidelines. Most important is that you need to set your fee as early as feasible. You are not to misrepresent them. It must be consistent with law. And you need to discuss any limitations of services that could happen if they can't pay. If you want to use a collection agency, you are allowed to do so, but you must notify the client and give them a chance to pay it before calling the collection agency. You are not obligated to keep working with someone, but terminate ethically and appropriately if they can't pay. You don't have to. You can see them free if you want, which leads us to general principle B, which is you are encouraged to offer pro bono services, but not required. Bartering is also addressed. As long as it's not clinically contraindicated and it's not exploitative, it's okay. Referral fees are a huge no-no. If someone refers you and you're splitting a fee in terms of services that are actually provided, like you pay them for the assessment they did for that client, that is fine, but it cannot be based on the referral itself. Referrals and fees. What else? When it comes to insurance companies, this is a big deal, actually. Insurance fraud is both illegal and unethical, and you should know that for the exam. Insurance fraud could constitute routinely waiving copayments, billing for missed appointments without the insurance company knowing, and assigning an incorrect diagnosis. Again, set the fee as soon as possible. And a little more on insurance, limits on treatment and fraud. So those are 3 ways that you can be committing insurance fraud. A lot of people are doing it without realizing. You need to also be really accurate about what service and fee services you're actually providing. And what about the limitations? They can deny treatment. So this is something that could happen and you need to be able to work with. If they don't authorize payment, what's the first thing you want to do? Appeal it. If that's denied, then you can discuss with your client an alternative payment method and try to work something out. Talk about the ethics code a little bit more. It is important to make reasonable efforts to plan for facilitating transfer of services in the event that something is interrupts it, like illness, death, or anything like that. Termination of therapy. If a client doesn't need the services, isn't benefiting, or is being harmed, terminate. You can also terminate when your life is in danger, whether it's because of the client themselves or somebody related to the client. And except where precluded by clients and third parties prior to termination, you need to provide pre-termination counseling and suggest alternative services. What about relating with other professionals? We're going to talk about both cooperation and when your client's seeing another professional. So cooperating with other professionals is really important to the practice, and confidentiality becomes an issue. So don't disclose anything that could lead to their identification unless you have prior consent, and only disclose to the extent necessary for the actual purpose of the consultation. If a client is receiving services from another professional, proceed with caution and sensitivity to the therapeutic issues. That's the quote. Carefully consider the treatment issues. So if it's something that is markedly different, if they do CBT for tobacco cessation and you are a psychodynamic, that's probably okay. What about advertising? With regard to advertising, a few things you want to know about. And it's basically you want to be clear, you want to be honest. Professional identification. So you need to be very clear about who you are. And there's California codes and laws about this. You need to include your license number, any professional activity. Don't misrepresent your qualifications. That could be your degree, your institution, your training, your competence, anything. And if you do, you can have your license either revoked or suspended, or so especially if it is willful. California law covers these things, and it talks about, so CCR 1397 with advertising. This is interesting because it says advertising can't promote excessive or unnecessary use of services. So everybody should have CBT. No, you can't do that. And they don't want you to say anything is based on fact or evidence. So no therapy advertisements can compare to another product, say it's based on evidence or anything like that. What else? If you change your workshop, you need to do it for a description of your workshop. You need to do so for a reason. If it's a class, let the class know along the way with reasonable time to adjust. Soliciting business. You cannot, well, the ethics code says you can't have in-person solicitation, or actually standard 506, no in-person solicitation uninvited if you're not invited. And in particular, if it's people that are your therapy clients and vulnerable to undue influence. But there's two things you can do. You can bring people in for the purpose of helping your client if you need their wife to come in, or if you're providing disaster or community outreach services. So here are the standards: avoiding false deceptive statements. You can't compensate others for advertising for you. You can ask people for testimonials, but not current clients or vulnerable clients. And finally, when you're giving a media presentation, you just want to be really careful and be very clear that there's no relationship established. So you're basing things on information, you're not giving advice.
In California, minors are people under age 18. They're generally not able to consent to treatment. Instead, it's usually the parent or guardian that does give that consent, and usually you'll have the minor give assent, which is like, they non-legal consent anyway. If there's a divorce, you just need one parent. The same rules regarding confidentiality and privilege apply to the treatment of adults. Treatment information, however, is most commonly discussed with the minor's parent or guardian, so the parent holds the privilege in many cases. In one area, the law is very explicit with regard to their rights, the parent's rights. If the parent sought medical care for counseling or counseling for a drug problem that was related to the child, the provider must generally disclose information about treatment upon request, even if they don't consent. So that's if the parent sought the care. Now, if that kid dropped out of that facility and found their way to another facility without their parents' consent, you might find yourself then in a different situation. There are several exemptions that lawfully permit a minor to consent to treatment, and these are for very good reasons. There are three kinds of minors we'll talk about: emancipated, self-sufficient, and at risk, that have different sort of stipulations around the extent to which, or if they need consent at all, and the parameters. So what are the three types of minors? And we've probably gone over this a little bit already, and we'll go over it more in terms of different pieces of the pie when you know about law and ethics, but emancipated, self-sufficient, and minors at risk are the three kinds of minors you want to think about. Emancipated is they've either gotten married, they've enlisted in the military, or they have a declaration from the court that they're emancipated. So what you need to remember there is they are 14 plus, live separate from their parents, with consent though, and they manage their own finances that are not derived from criminal activity. So this is someone who can really stand on their own feet legally. The court may emancipate when those conditions are met, if they think it's not contrary to their best interest. Excuse me. Self-sufficient, they do not. So an emancipated minor has the same rights as an adult. Emerson. So, sorry. So with self-sufficient, the only thing they can do is consent to their medical and dental treatment. And that's because there are some kids on their own who are very much on their own, and we don't want them to not be able to get medical or dental treatment because they're currently estranged or in just a strange situation with their parents. It might not be CPS worthy, but so these individuals, these kids, are 15 years plus. So to be self-sufficient, to not have that sort of if you haven't met all those hurdles of being emancipated, then you need to be a little bit older to have these lesser hurdles, because these hurdles are simply that you live apart and you manage your own finances. That's it. They've got to be 15 though, not 14. And it doesn't matter if the parents consented to them living apart. It doesn't matter where they get their income, but they're apart and they're managing their own money. So they need to be able to go to the doctor or dentist. That said, they are not protected in terms of privilege and all of that, and confidentiality. The dentist and doctor can give the parents a call and tell them about, anything. And then minors at risk, we'll talk more about what those are, but Typically, if a minor is 12 years or older and with different services can receive treatment without consent. With STDs and pregnancy, it doesn't matter. Um, they can get treatment for those things, no matter how old they are. So that's that part.
Talking about minors, we will talk more about different ages, but 12 is the earliest that a kid can be seen without consent of parents, and 14 is the earliest that they can be emancipated. 18, of course, is adult, and then 16 will be more pertinent when we talk about sexual abuse reporting. Treatment of minors is a tricky business. We're going to talk about consent and access to records. Consent to treatment by emancipated minors. First of all, an emancipated minor is considered an adult for the purpose of health care and can do things without parental consent. There are three situations for emancipation: marrying legally, enlisting in the military, or court declaration. The court declaration requires that they're 14, living separately, the parents agree, they can take care of their own finances, and they do not get their money from crime. So what does the California Code say? Yep, they are an adult for the purpose of psychiatric care, but it doesn't change things like driving, drinking, voting, and rape. Okay, well, what about not emancipated minors? This gets really kind of tricky, and yet it's actually very simple. First of all, you have to distinguish between, this is really about, can they consent to be treated without their parents' consent, and what about the parents' access to their records? So in terms of consenting to treatment, you need to consider first whether it's just an outpatient facility, and secondly, whether this is a more kind of serious setting, a runaway house, inpatient setting, or Medi-Cal is covering it. Now, if it's outpatient, it's a little less stringent. They need to be, the professional needs to believe they're mature enough to participate intelligently. They shall include the involvement of the minor's parent or guardian unless they think that it would be inappropriate. If the minor is consenting, their guardian's not liable for payment, and this does not apply to minors, who receive Medi-Cal, like we just said. So 12 years old is an important number to remember with these. If, however, they want to get services at an inpatient facility, not only do they have to be able to participate intelligently, as before, but in this case, there really needs to be a serious threat associated. Not just, it would be inappropriate. This is, alleged victim of incest or child abuse, or they could be seriously physically or mentally harmed without services. Anything else to know? Well, they can receive treatment for drug and alcohol-related problems under California Family Code after age 12, and you must try to document the guardians. And if you decide not to, you need to document exactly why. They cannot receive methadone or other replacement narcotics, however, without parental consent.
So we're going to talk about consent for treatment of minors that are at risk. The first thing to talk about would just be, there's two categories you'll see here. One is where there's not only is the minor able to give their consent, but they are really protected in terms of their confidentiality, and the healthcare provider is not even permitted to inform the parents or guardian. Even if they wanted to, they would be breaking the law. So that applies to pregnancy, STDs or STIs, and rape victims. The only difference between these is that for rape victims, the minor does have to be above the age of 12. For pregnancy and communicable diseases, Really doesn't matter the age. There are a few things to just note. So with pregnancy, you can get all the you can do contraception, abortion, all of that. You cannot have a minor cannot get sterilized though without consent. In terms of communicable disease, um, you can get treated, assessed, all of that. They if the minor wanted to share their records, the minor would have to give signed consent, which is true generally when your information is protected. And then for rape victims, just to note that again, you can only share the records with signed consent. Now the situations in which the minor is at risk, but you do need to attempt to contact the guardians. That's in the case of sexual assault, not rape of a minor older than 12, but a sexual assault. And if the minor wants to get treated for drug and alcohol. Now, they still are able to consent to their own treatment. So, whereas with the first category, they could consent and it was also privileged and confidential. In this category, it's not about being confidential, but it does mean that a parent can't get in the way of a kid getting emergency treatment after they've been assaulted, or a kid who's in a lot of trouble can get the treatment he or she needs for drug or alcohol abuse. There are always exceptions, especially if there's abuse or harm happening at the hands of the parents or guardians. So of course that's going to apply here too. So with sexual assault, yes, it is the law that you must attempt to contact the guardian, unless they're the suspected perpetrator. If they are potentially the one, and there's a reasonable suspicion on the part of the therapist that the parent is the one who committed the assault, then you do not need to. You're not required in that case to contact the guardian, but as always, you're going to want to record that because it is mandated to contact them. So if this falls under that exemption, it needs to be documented clearly in your records. And similar for drug and alcohol treatment, if there is some reason, which may be there at times, that it's not appropriate to contact the parents, then you need to document why. And with minors that are consenting to their own drug and alcohol treatment, this is conditioned on a few things. This doesn't just happen willy-nilly anywhere. This doesn't often, probably for the most part, doesn't happen in a private practice. These are treatment centers that are typically under contract with the state or the county. And these are minors that are already 12 or older. And no matter, even if the parents decide they don't want to get involved, unless the parents give consent, they cannot receive methadone treatment or other replacement narcotics. They cannot consent to that.
So, treating a minor without parental consent, here's your 3 things to always remember. They have to be mature enough, there must be a rationale, and you need to put in your notes why. And just, remember, you can't give them narcotic treatment without consent, even if they're legally consented to everything else. What about these not emancipated minors that we were talking about? So not most minors are not. So what about them? Well, they have a right to their own records, but so do their parents. And however, if there would be a detrimental effect on the relationship, or if there's physical or psychological well-being in jeopardy, the provider can deny permission to the parents. And they have to put that in writing, and they need to also permit inspection by another professional to kind of confirm that that's actually fair. And this is actually consistent with HIPAA. Who has access to records? Basically guardians. And if Even if someone's not in physical custody, they still have their rights. And words of the court are called 300s, and the court is the one who kind of plays the role of guardian, but often they will have a social worker or someone that they kind of send to act on behalf of the court. Okay, now we're getting into the world of clients that are a danger to self and others. We're going to talk about Tarasoff, duty to warn, as well as involuntarily committing someone. Different laws that are important to know in regards to this, most importantly Tarasoff and Ewing, but also CMIA, when does it not apply, and also what about HIV? So the Tarasoff case, this woman was in Europe, and Tarasoff said, or this guy named Podar said, I'm going to kill her. The therapist went to the police and his supervisor. The supervisor was mad that he did it. Nobody did anything. Yeah, Podar killed Tatiana when she came back, and the Supreme Court ended up saying that you do need, that the therapist did the right thing, but you also need to warn the victim. So he was actually in trouble for not warning her. So the Tarasoff decision is two things. Is the client readily identifiable, and is there a serious threat of physical violence? If those are both, there is the duty to warn and protect. And you need to go to both the police and the victim themselves. And another thing to know is the client has to tell you about this. It cannot be, well, it can be someone else, but we'll go into that. So the client tells you about somebody else, they're going to go kill this person. Nope, can't break confidentiality there. Now Ewing expanded it to say, hey, if somebody's wife calls and says he's about to kill XYZ and he is your client, this is a case in which if there is a threat of grave bodily injury, the duty to warn can be triggered. The confidentiality, this act, well, we've got two things. One, we've got the 1024 and then the CC 5610. You can disclose, and so this is different. So even though you cannot invoke Tarasoff if your client says, hey, this guy I know is going to kill him, what you can do is you can invoke section 5610, where you can disclose something if you really believe that doing so will lessen a real threat to a person or property. When does it not apply? If it's not the client, so we're talking about Tarasoff again. Tarasoff does not apply to other people being the dangerous party other than the family member if there's no reasonably identifiable victim, or if they're threatening suicide, that's a different case. So suicide, that's a 1024. It is never a Tarasoff or duty to warn. HIV, and you're getting into a little bit more of a complicated territory, and this is a gray area. Basically, in California, physicians are protected if they disclose, but there is no protection for psychotherapists if they're disclosing HIV status. You really aren't supposed to breach confidentiality in the state of California here, but if you think that they're in a manic episode and they're HIV positive and sleeping with 40 people, in that case you probably want to say they're a danger to others due to a mental disorder. So then you can involuntarily hospitalize them, which is not Tarasoff, but it is one way to protect everyone. So 1024, this is kind of your Tarasoff alternative, because suicide is never a duty to warn. In fact, you're not legally required to do anything, but you might be sued for malpractice in the ethics code You can get in real trouble if you're not doing what you should be doing professionally. 1024 um, can be applied whenever you think there's danger, basically. Not as kind of casually as I just made it sound. But the thing about 1024 as opposed to Terrace Off is you don't have coverage or money to protect you, like where Terrace Off there is. The client can sue you if you break privilege here. Involuntary commitment. Okay, now we're getting into the different kinds of holds and the different reasons. So it could be danger to self, others, or grave disability. In addition to these conditions, it needs to be because of a mental disorder or chronic alcoholism. And if the client has refused to comply with the recommendation, then it can be involuntary, but certainly give them the chance to go voluntarily. So here's the codes in California. 5150, you have no rights. And it's important to remember this is actually, 5150 is actually for adults, 5585 is for kids, and we'll talk more about that. But at this point, you have no rights. But once you get into 5250, which is the 14-day hold, now you're believed to still be a danger, but your rights, now you can file a writ of habeas corpus. You start to have legal rights. And post-certification, there's a split now between the different reasons you're being held, and different laws apply. So with a 5150, you need to specify why. 5230 is for just alcohol and drug use. Grave disability, can't care for self. It cannot be an intellectual disability. And you're not holding someone just because they have a mental disorder. You're holding them because this mental disorder is putting them in harm's way.
This is unlikely to be on the exam, but in the event that you ever have to hospitalize or involuntarily commit a patient or someone, or you're working at a hospital, I think it's also interesting and important to have a sense of what it's like for those clients and what it's like for those people. What are they actually getting themselves into? Is it a positive thing to 5150 someone? Is it a negative thing? It probably depends on the facility that they're being sent to. It's probably not all the same. But we'd like to think that we're helping them. So one thing that exists is a bill of patients' rights and basic rights that people have when they have been involuntarily committed. So basic to whether it's for mental illness reasons or anyone at a state hospital, any patient has a right to wear their own clothes, use their own toiletries, and keep money for small purchases. So the basic premise is going to be they kind of still are able to have a little bit of their own space and their own stuff, and also to have some autonomy over themselves and an ability to be in communication with people outside. So that means they have their own storage space. They can have visitors every day. They can have access to telephones and writing materials. And if they want, the autonomy piece is that they can refuse electroconvulsive treatment and or psychosurgery. For mental illness patient rights, there's some more that are added on here. The first, so I guess the basics are that they're going to have as least restriction of personal liberty and choice as possible. So they still have the ability to make choices for themselves, have advocates, practice their own, practice their own religion, and live life in the way that they, as much as possible, allow them to live life as freely as they can. And of course, that they're really well cared for. And it should go without saying. So in some ways, it's like, well, why? Of course they have a right to prompt medical treatment. Of course they should be free from unnecessary isolation, abuse, or neglect. But you can imagine that in a state facility where there's a lot of people who are not doing well and understaffed, that actually these are things that could go out the window and not a good part of community, but something that can happen. So it is important to be very explicit about the rights that people have. So what that looks like is that the patient can have an advocate. They can refuse medication if they want, but they do have a right to receive treatment and prompt medical care as much as possible to facilitate that they can be independent, which also means that they don't have excessive restraint, abuse, neglect. They can socialize, practice their religion, be physical, and not have any hazardous procedures. So you can see it's as much as possible in this difficult situation, you want to keep their basic human rights intact.
Okay, let's keep talking a little bit about 5150. This is only for adults, and this is California Welfare and Institutions Code. Just to remember, 5150 does not fall under Tarasoff, and it's not required to 5150 someone, but it could be malpractice, serious malpractice issue if you don't. Determining danger to others. On the test, they might want to know how, when you have to evaluate, is this person really a danger? Think about perps. Do they have past behavior? Are they drinking? Can they think cognitively? Did some major stressor happen? And do they have a plan for what they're going to do? Remembering that a weapon in the house and danger goes up dramatically. So key to grave disability is that if any adult shows up and says, I'm willing to take care of them, then you can immediately waive that it's grave disability. The 14-day hold is what comes after your initial 72-hour hold. And what changes is that, again, you have the open, you can now have a writ of habeas corpus. This is called a certification, and it has to be signed by 2 people. It can be reviewed. And that must be within 4 days of probable cause hearing. So you can challenge it. And this is to try to protect not involuntary, but kind of unlawful imprisonment. So the third part is post-certification. And if it's suicide, it turns into a 5260. And this is another 14 days. But after that, you have to release them. That's the kind of last stop. With grave disability, you can get 30 more days now, and now you need to either initiate proceedings to find a conservator or something like that. But that's generally what's happening at that point. You can't keep holding them unless those proceedings are in process for the conservator. And serious danger. Now here you can the 5300 can get reinstated over and over again until they're not a threat anymore. This can be put in place if they've continued to demonstrate danger while they're in custody, if they, in some way, whether it's through a threat, whether it's actually harming people or attempting harm. So what is conservatorship? It's anyone that the court appoints. And somebody who's going to take care of someone who is gravely disabled is the result of mental disorder or chronic alcoholism. This can be 30 days, short-term or long-term, for renewable 1-year periods. When you involuntarily commit a minor, it is not a 5150, in fact. This is actually a 5585.5. You must, though there is exception, call the parents and get authorization from them. This is really primarily the case, but of course there's an exception, which is when, as a result of a mental disorder, they're a danger to themselves, others, or gravely disabled, and that authorization is not available, you can't get a hold of them, for example, then someone designated can bring them in for treatment. Meanwhile, you need to keep trying to get in touch with them. So the facility should be trying to get in touch with them. So that would be the case with the 5585.5, especially for, non-emancipated minors, of course. Reporting and committing questions on the exam. As soon as you see that there's somebody who's dangerous, you're starting to get into, um, do I report or do I commit? So if there's abuse or danger, you need to start thinking, okay, is this a requirement or a possibility? Is this terrace off or is it a 1024? Suicide, as soon as you 5150 someone, you open the 1024 door, which is because you broke confidentiality to protect someone. Okay, we're going to talk about reporting abuse. We all know the general fact that elder and child abuse are mandated reports and that therapists are mandated reporters. Okay, let's talk about child abuse reporting. We need to know about filing reports, who to file them to, what happens when multiple people heard about the abuse, and what are things that are required to be reported, and what are things that might be reported, and also knowing what can happen if you fail to do so. So what are the reporting requirements? Well, we have California law, and specifically with California law, you need to submit a written report within 36 hours, report it to the appropriate people. One person can report if there's a team that knows. And this doesn't matter if you're emancipated or not. The key with mandated reporting is if you have a reasonable suspicion, you have to report it. It doesn't matter if it's hearsay. The question is, using your faculties, is this reasonable to think that something's really happening here? There is a number of kinds of abuse to be aware of. First, of course, is physical abuse. And this is clear that it's something that's purposely inflicted harm, ruling out mutual affrays among minors. Sexual abuse, this could be either assault or exploitation. So obviously anything like rape or incest, that is always reportable, no question, and must be reported. Lewd and lascivious means that someone's doing something to gratify their sexual desires with a child, and that could be anything odd that they might do. Sexual exploitation is pornography and prostitution. Neglect, severe neglect, there's severe and general neglect. Severe is actual like physical needs are not being met, they're in danger in terms of shelter and malnutrition. General is more, they're not providing adequate food and supervision and stuff, but there's not physical injury yet. You also want to know about willful cruelty or unjustifiable punishment. That is a mandated report as opposed to emotional abuse, which is an optional report. So, yes. And finally, there's unlawful corporal punishment. If you're willfully inflicting harm and leaving bruises and such, that is unlawful corporal punishment. What else to know about California law? There is a neglect code and an abuse and neglect code, and that has what we just discussed in it. Now there's also a separate code that is the emotional abuse, and this is a may report, but it's up to you. So, law and ethics with minors. Knowing a little bit more about lewd and lascivious, this is actually mandated. And if anything creepy happens with a minor and the person is 10 years older than them, it's mandated. There cannot be full sexual relationships with anyone above 21. Period. People that drink cannot do anything with people under 18. Cannot have a full sexual relationship with anyone under 18. And finally, sexting actually is a mandated report, so just know that. Legality and mandated reportings are not one-to-one. So just know also about the two laws in terms of being under 16, whatever those are. So child abuse, if you want to report physical violence, You're not supposed to report spanking on the butt. You are supposed to report using implements and bruising and such. Domestic violence is now can be categorized as emotional abuse. So you're not reporting the domestic violence, you're reporting emotional abuse to the child that is resulting. And this is actually mandated. So that's part of why I'm a little confused here, but that is part of why they put emotional abuse into the code to prevent kids from having to witness domestic violence. So sexual versus emotional abuse. Sexual abuse is always mandated. Okay, so watching domestic violence is in fact a mandated report. Okay, so to be clear, it is mandated. Emotional abuse, however, is when it's, I guess if you think it's abuse, then I think you are mandated to report it, but it's subjective here. So there's not an objective rule. You decide if it's a reasonable suspicion. And now, what about consensual sexual intercourse? Basically, if a kid's under 14 and the other is above 14, this is a report, period. You do not have to report if they're both under 14, or if the minor's 14 or 15 and the partner's no more than 10 years older than the minor. So that's a little contradictory of this chart, which says that it's a mandatory report if a 14-year-old is having sex with a 21-year-old. So I guess, okay, so maybe that is sexual acts, but once it's full intercourse, 21. Okay. And then the 16 and 17-year-olds, this is not mandated, it's subjective decision. So 16 and 17-year-olds is the 10-year rule, but you decide if it's abuse. Sharing confidential information. We kind of talked about confidentiality before, and that there's this idea of general, that if it's for the purpose of providing healthcare, you actually don't need authorization. So you can exchange information with your personnel team, and this is still confidential in court. So testimony is not permissible from someone else who heard about your client. Okay, let's talk about immunity for making reports. Mandated reporters have immunity, both criminal and civil. If you make it with reckless disregard of the truth, then you don't, but other than that, you do. Now, what about liability? So there's a lot of pressure, and in a good way, I believe, to make these reports as a mandated reporter, because you can face criminal penalties if you fail to report child abuse. It may have civil liability and disciplinary action as well. However, the penal code we're going to talk about for a second is that if you fail to report, you just want to think misdemeanor, 6 months, $1,000. If you fail to report and there is death or bodily injury, then we're talking up to a year and up to $5,000. We are legally required to tell people when we file reports. Ideally, you have them do it yourself, and there's always these safety exceptions. So if you think that telling them is going to cause more violence, you do not need to. What about adults who are abused as children? The key here is, unless the victim's still under 18, this is not a mandated reporter situation. But if you have reasonable suspicion that this person's still out there victimizing children, well, there you go. Doesn't matter if it's hearsay or what. As soon as you think there's a reasonable suspicion that's coming up in your professional relationship, you must file a report. As a mandated reporter, you are still given protection if you make reports outside of your professional role, though it's not mandated. If you see child abuse in the grocery store, you're not in a mandated situation, but you are still protected if you choose to do so. You can always call CPS. Cultural issues. Basically, we can't use cultural issues as a means to get out of reporting things. So if someone says, "Oh, we beat our children at the age of 13 to initiate them," well, then you can let them know, "Hey, I mean, if you want to let them know, hey, you respect that, it's a cultural thing, but I have to report it." You do need to report it though. Third party information. This is what I was saying about whether you're in your professional capacity or not. Any reasonable suspicion in professional capacity, report. Up to you if you're not in professional role. Okay, elder and dependent abuse, adult abuse reporting. We've got some reporting requirements here and responsibilities. You need to know when and how. You need to know who's authorized to receive the report. And you're not required to file the report if the dependent has experienced an act that constitutes reportable abuse, but there's no evidence, they have dementia, and they're subject to court-ordered conservatorship. So it's up to you to decide if there's reasonable belief, but just because the elderly person says it is not make it mandated. Whereas if a kid does, there's a little less wiggle room there. You only need to report spousal abuse if there is the age differential. Okay, so when and how? If it's severe, you need to make it within 2 hours. Call law and call the local ombudsperson within a day. So, who is an elder? That's someone in California 65 plus. Dependents are anyone who don't have full capacity, and they are admitted as an inpatient to a 24-hour health facility. Okay, I'm going to try to make the reporting of elder abuse as simple as possible. First of all, you need to take into account the location and the type, and then you decide who to report it to and how long you have to do so. So there's long-term care facilities, state mental health facilities, and then other. So with long-term care, here's the different types of abuse that can occur. Physical abuse with body injury, physical abuse without body injury, and then physical abuse that's believed to be caused by actually a resident with dementia. Fourth, of course, there's abuse that's other than physical abuse. When we're talking about physical abuse, you need to call law enforcement immediately and then follow up in writing to the ombudsperson, the licensing agency, and the law. So long-term care physical abuse, you're ASAP calling the police, and then you're writing all three concerned parties. With serious bodily injury, you need to write reports within 2 hours. Without serious bodily injury, you have 24 hours. Now, when it's caused by a resident with dementia, you need to call immediately or within 2, really as soon as possible, but your writing doesn't have to happen for 24 hours. So that's kind of a split between the first scenarios. Now, when we're talking about other than physical abuse, you need to call and write to the ombudsperson and the law enforcement, but there's not a time stipulated on this. So I guess they don't consider it as dangerous. Now let's talk about state mental health. So there's kind of abuse and neglect that's causing injury, that's sexual in nature, broken bones, and then there's any other type of abuse or neglect. With the more severe abuse and neglect, you need to call the investigators of the state and the law enforcement within 2 hours. If it's other types, you get to choose. You call one or the other, but you should be calling someone immediately in both cases. And finally, any other location without any other kind of abuse, you need to call Adult Protective Services or the police immediately, and then you need to follow that up with a written report within 2 days. So that's the long and short of it. Okay, so what are the types of abuse that you can face as an elder or dependent? You've got physical. That's pretty obvious what that could be, but it can also be like sexual assaults, lewd, lascivious acts, etc. Also using chemical restraint or medication for punishment beyond what the physician wanted. So you can imagine kids like drugging their parents to keep them calm or something. Abandonment is just leaving them without care when they're not able to, when a reasonable person wouldn't leave them there. Abduction is you're removing them from California when they don't have the capacity to consent to that. Isolation is when you deliberately prevent them from receiving phone calls and visitors, and you isolate them from other people. Now, they may not constitute isolation if they're performed in accord with instructions from a physician or if there's a danger to the person's safety or property. Financial abuse happens with elders, and that's when you take the property of an elder wrongfully or defraud them. Neglect is when you're responsible and they're in your custody and you are not exercising the same degree of care another reasonable person would. So you'll notice here in elder abuse, they're talking about what reasonable people would do a lot. And this can relate to hygiene and then all those basic necessities like food, clothing, shelter. And thirdly, it can be protecting them from hazards or malnutrition. So neglect also includes self-neglect. That's the result of impaired functioning in substance abuse. Okay, so those are the types of abuse that has to be reported. Now, reporting that's allowed is when you reasonably suspect that their emotional well-being is endangered. But you don't have to make that report. It's up to you. Okay, so we'll talk about immunity and liability again. Mandated reporters are not civilly or criminally liable for making a report that is authorized by law. So that's pretty good, unless it's proven that you knew it was false, which is ridiculous. Why would you do that? But people are crazy, so therapists and otherwise. Liability, this is the same as with kids. You can face criminal penalties if you knew of abuse that you did not report. Misdemeanor punishable 6 months, $1,000. And then if it results in injury, you've got a year and $5,000. Next up is sexual misconduct. Okay, so sexual misconduct. We're going to talk about laws that pertain to sexual relationships with clients. In addition to laws that pertain, we'll talk about the ethical standards and also what happens when it's a colleague and a client and it's not you as a therapist, psychologist, know of it. So let's start with the laws. We're going to talk about criminal liability, civil liability, and the disciplinary action by the board. Criminal liability says if you engage in an act of sexual intercourse, sodomy, oral copulation, or sexual contact with a former patient or client when it is terminated and when it's terminated for the purpose of engaging in those acts, this is guilty of sexual exploitation. So, in no instance shall consent of the patient or client be a defense. So this is a criminal act. Criminal. Okay, what about civil liability? You can also be have civil liability. The patient can say that you caused injury to them, and this could be during the period they saw you, within 2 years following therapy, or by means of deception. Finally, this is defined as unprofessional conduct by the board. And disciplinary action is specified, and if they find that there was sexual contact within 2 years, they will revoke your license, and that shall not be stayed by the administrative law judge, whatever that means. I don't actually know. So, criminal liability, depending on the number of sexual acts, you were talking about different levels of crime. If it's one sexual act, we're in the misdemeanor category. If it's 3, it's a felony. And 2 sexual acts is called a wobbler. So that means the court can choose. What are the standards that pertain ethically to sexual relations? Well, first of all, you can't do it with current clients. So that's standard 1005, and that's pretty straightforward. Former clients, not for 2 years, only under the most unusual circumstances. And if it does happen, need to really demonstrate you need to bear the burden of demonstrating that there's no exploitation. And that means addressing a lot of different factors, like the nature of the therapy, time passed, circumstances of termination, client history, their mental status, how likely is it to adversely impact them, and did the therapist at any point during the course of therapy suggest that it could happen post-termination? That's a big no-no. We are also prohibited from engaging in intimacies with people we know are close to the client. And you can't quit seeing your client to circumvent that. So you can see that's there. 1007, you cannot provide therapy to a formal sexual partner, period. No exceptions. That's it. Done. And finally, students and supervisees. If you have evaluative authority, that's not appropriate. So there is not a 2-year rule here, however. But in that relationship is still considered an unethical multiple relationship and could be a real problem. However, it changes down the road. So if you learn that a colleague has had sexual relationships with a therapy client, you are ethically and legally obligated to take steps to protect them. When a client reports that, so you know that you're required to give them the brochure, professional therapy never includes sex, if your client tells you. And of course, if it's a client was a minor, then if that therapist is still seeing minors, then you need to make the report. However, it's similar to any child abuse report. If they were an adult, if you know that therapist isn't practicing anymore, then it's not a report. When a colleague discloses, so this is when it gets really tricky. What if a colleague says, hey, I'm having sex with a client? You need to think really carefully. This is not something you can resolve informally, but you can't file a complaint if it would violate the client's confidentiality, because that takes precedence. Okay, we'll discuss forensic issues. Key here is to know about malpractice. So what can happen to you in the courtroom, subpoenas, and psychologists in the courtroom. The specialty guidelines for forensic psychology help clarify some of our roles and responsibilities in this field. When we are in the courtroom, this can relate to a number of things, including the insanity defense, expert witnesses, etc. So let's define forensic psychology to start. As in the specialty guidelines, this is referring to the professional practice working within any subdiscipline of psychology when they use that knowledge to assist in law. Expert versus fact. If you're asked to testify as an expert witness, this means that the court has decided you have special training or experience relevant, and the court is the one that designates you as an expert. The fact witness is saying facts. What did you see? What did you hear? What did you observe? You cannot here offer an opinion. However, you can say their diagnosis was this that I gave them, because that's more of a fact. You can only provide that information about your client with consent or court order, however. And why is that? Well, that's because of privilege. Testimonial privilege. So remembering that, and we'll talk more about this, but privilege is a legal term, and the client in pretty much all cases is the holder of privilege. The therapist may waive it on their behalf, but only with permission from them. Informed consent. Okay. Unless court ordered, we must obtain informed consent before proceeding with a forensic examination. If they won't proceed, you can postpone it or have them contact their client. You can't force someone to, proceed if they don't want to, but, there is no confidentiality there. But you are obligated to inform them of this as soon as possible. They need to know the parameters. If there is, so you can conduct the examination over the objection of, but if they still don't want to do it, tell them to contact their attorney, and then you will notify the retaining party. So that's important to know, is you are responsible for notifying the retaining party. And when a person lacks that capacity, well, I think this is pretty obvious. The person who's legally authorized may do so for them, and then, as always, you're seeking assent. The insanity defense. The legal conditions for an insanity defense are specified in the Penal Code. So you can only use this defense when there's a preponderance of evidence that they were incapable of knowing and understanding what was happening at the time of the offense. So that's important. This is not about, are they insane now? It's when they committed the crime. So it could be a seizure, it can't be just a seizure disorder or a personality disorder, or like having that. It has to really be something very specific to that moment. Not competent to stand trial is different than the insanity defense, because this is when you're determining if that person can even be in a trial, because it's to stand trial, you must have an ability to understand what's happening. If you can't comprehend, that's not fair. And so the trial will go on once the person is competent, but until then, no. And you can use the mini mental status or a mental status exam to help. You don't decide, but you give them your assessment. The subpoena is a really important thing to know about. What is that? Well, it's a document that gets delivered to you saying, we need you to give testimony, and a subpoena jucis tecum requires you to bring a specific document. So how do you respond? Well, the first step is it legally valid? Often they're not delivered legally, so you want to check out that it was legally valid before you do anything. So you will contact the client and or the client's attorney to figure that out. Next, you're going to want to negotiate with the requester, try to file a motion to quash it if you can. so at first, so let's say that didn't work out, then you do need to show up in court. But you can assert privilege on the client's behalf. And until a court orders you to release information, you don't have to. But once the court orders you, you're into contempt of court if you don't comply. So privilege, the psychologist is never the holder of privilege. You are claiming it on behalf. And don't acknowledge that the person's your client when they deliver the subpoena, because that's a breach of confidentiality. So this is where we get into subpoenas and court orders when we talk about the holder of privilege. With a subpoena, a therapist can invoke privilege on the client's behalf. They must come to the court if they are subpoenaed, and they need to let the client know they had it. And unless there's permission to release it, they do not give over that information. However, with a court order, indeed, you are required to give that. And this won't happen ordinarily unless the judge has really determined that an exception applies after reviewing materials. So let's compare court-ordered evaluation and court-ordered therapy, because there's differences in terms of confidentiality. Court-ordered evaluation is just an exception to confidentiality. The results are intended to be reported to the court, so there is none if the court ordered an evaluation. But this does need to be explained to the defendant beforehand. That is ethically required. Court-ordered therapy, it's not. It depends. So it's usually offered as an alternative to jail. So a lot of times there is already an arrangement where their information will be released, and they just need to have informed consent about that. And they can always go to jail if they don't want to. But there are some exceptions with treatment settings connected with the court. So if the client seeks the therapist program, sometimes there is confidentiality and they need consent. But there are treatment programs connected to courts where it's kind of established already, and just the patient needs to know that. So malpractice is the direct dereliction of duty. Talk a little more about that. So the conditions are these 4 Ds. You must have had a professional relationship where there was a duty of care legally. There's a demonstrable standard of care that's been breached. This is where the ethics code ends up kind of melding with the law, because they can say, look, according to the psychologist's ethics code, you didn't do X, Y, Z. Did the person actually suffer injury? And then was the injury actually the result of the dereliction of duty? Well, what are the types of compensation you can get? Award, nominal, and punitive. Reward is trying to, restore balance in the universe. Nominal, something happened, okay, yeah, but not much we can do about it. Not much way to translate it. And then punitive is what you did was bad, and we're punishing you. How can you reduce your risk for malpractice? Experts say that being familiar with law and ethics is the most helpful thing to do, and maybe even above that is maintaining, in line with that, very well-organized records. And another suggestion is to get coverage. Custody issues. Just because you have timeshare with a kid, you don't necessarily have legal rights. And then vice versa is true. Just because you do not maintain physical custody, but you do still have legal custody, then you do maintain your right. So really, one is not the other. You always refuse to offer an opinion for one parent. Yeah, that's that.
Okay, so we're now going to talk In ATABS, this is section 11, and Psych Prep, it's section number 1. But the laws that are regulating the practice of psychology. So we're specifically going to talk right now about general business practices, so licensure requirements um, and other such things that guide us. As we move into this topic of laws, ask yourself and think, what are the main areas that I need to know about when it comes to psychology laws? And it has to do with your practice, right? Of course, where you can, how you can do it. Has to do with necessary supervision requirements. So you need to know that both as an intern as well as someone who might supervise or oversee different programs. You need to know about the Board of Psychology and what actions they can take against you if you violate the ethics code or anything else, and mandatory continuing education. So let's talk really briefly about this Board of Psychology. The purpose is to regulate providers of psychological services with the goal of protecting the public. Always remember that it's about protecting the public. It's not about making sure everybody's super great. It's about protection. To accomplish this goal, they'll establish minimum qualifications and levels of competency. So all of these hurdles that we have to jump through are saying you are minimally qualified and competent. Hopefully we're better than that, but the board licenses or registers providers who possess the skills and qualifications to provide safe and effective services according to accepted professional standards. So you'll hear that a lot of what is the professional standard, and that's something that you always want to know. The board regulates not just licensed psychologists, which we are all soon to be, but also psychological assistants and registered psychologists. A licensed psychologist is what you will be very soon, and you can practice independently in public or private settings. Psychological assistants have at least a master's degree, and they can provide limited services, but they must be under the direct supervision of the licensed psychologist or a board-certified psychiatrist to whom they're registered. A registered psychologist, they need to have at least a doctoral degree, 1,500 hours already of supervised professional experience, and this is the real kicker. They're registered at a nonprofit community agency that receives a minimum of 25% of their funding from the government. And this registration is in effect for 30 months, so a little over 2 years from the date of issuance. It cannot be renewed. You cannot re-register as registered psychologist. The practice of psychology is defined as providing to individuals, groups, organizations, or the public any psychological service involving the application of psychological principles, methods, and procedures of understanding, predicting, and influencing behavior. So they're just throwing everything in there. But are you providing psychological services? Does anybody? Okay. Does it involve applying psychology of any type, the principles or the procedures, etc.? And is it for the purpose of understanding and influencing people? Well, there we go. That's the practice of psychology. It's not prescribing drugs. It's not surgery or electroconvulsive therapy. The board investigates allegations of unprofessional conduct, fraud, and illegal behavior, and they institute disciplinary action when warranted. The board also periodically checks to see whether providers are in compliance with the code, and they base their standard on the ethical principles of psychologists and code of conduct of the APA. To facilitate the goal of protecting consumers, they require all licenses and registrants post the following, and that is the notice to consumers. The board consists of 9 members, 4 of whom are public members. Now that's very interesting, and 5 of whom are licensed psychologists. The terms are for 4 years, and a member may serve no more than 2 consecutive terms. The governor appoints 2 of the public members, and the Senate Rules Committee and Speaker of the Assembly each appoint 1 public member. The governor appoints all of the licensed members. Very cool. The board annually elects a president and a vice president from among its members. I might have seen some of them when I was in Sacramento. Notice to consumers. So moving on.
Okay, so let's see if we can make this fun. This is the field we're talking about. Here I am studying so hard to be a psychologist, and what is this thing that you have to go through so many hoops to get to, and why? So we have the Board of Psychology, and these are the folks that give out these licenses. What is their goal? To protect the public, and this is accomplished by regulating the providers of psychological services. They are in charge of regulating licensed psychologists, psychological assistants, and registered psychologists. So these are their responsibilities. Let's talk about licensed psychologists. Who are these people? And how do we know that they deserve this supposed license and are trustworthy? Well, first of all, they have a doctorate degree in some form of psychology, and clearly that means they've gotten many, many years of knowledge and coursework, and that included substance abuse, sexuality, child abuse, spousal abuse, and aging and long-term care. So substance abuse is a whole quarter, but these other ones are like workshops. So sexuality, 10 hours, child abuse, 7, and aging is also 10. And then the spousal abuse can just be a 2-year. It used to be 2 years, but now it's 15 hours. Okay, so yeah, that's actually a lot. Okay, so here they have their degree in particular coursework. That means that they can fulfill their ethical requirements. They also need to have experience. You don't get your license until you have 3,000 hours of experience, and that needs to occur within a 30-month period. So you have 2.5 years to get those. You can't just extend it over the course of 10 years. They also need to have passed the EPPP and the CPSE, and this really means that they've had to verse themselves in the ethical, not only the knowledge of the field, but the ethical standards. So they actually know what their license means. If they've already been licensed 5 years in another state, instead of taking the CPSE, they just take the law and ethics one, because it's assumed they know what they're doing with the psychology part, and the California board doesn't need to worry about that part. They just need to catch you up with our state. What about psychological assistants? These are folks with a master's degree at minimum, and they can provide services, but they have to be supervised either by a licensed psychologist or a board-certified psychiatrist who can only supervise up to 750 hours. They cannot do all of those hours. Also, just important to know in terms of going back to psychologists briefly, you cannot practice psychology or represent yourself as a psychologist without a license, unless it's otherwise provided in another provision. Folks who are licensed in another state, this is interesting, they can provide services in this state for a period not to exceed 30 days in any calendar year. So you could come here for a month and offer therapy. You just have to leave. You can't set up a long-term practice. Which also means that if you're on vacation or, there's all sorts of laws, but it gives you a little leeway. However, let's say you move and you're licensed in another state and you want to become licensed in California, you do need to take the CPLEE, law and ethics. That, of course, everyone has to take that. If you've been licensed for 5 years elsewhere, like in the States or Canada, then, as soon as you take that exam and put in your application, you can actually start practicing without your license once you submit the application. And that has a period of 180 days, or once you leave. Supervised professional experience. Okay, so we talked about, so now we're going back again to the psychological assistants. We talked about their hours, 30 months. If both years of the experience are completed postdoctorally, then you have a 60-month period. So the idea being 1,500 has to happen within each, with 2.5 years each. So you basically overall have 5 years. Predoctoral. Okay. There's 4 ways you can do this: a formal placement, APA, or CAPIC, You can be an employee in an exempt setting. You could be a psych assistant with the board, or you could be pursuant to a mental health Department of Mental Health waiver. Postdoctoral is similar. You could be in an APIC program, not KPIC this time. That's just pre-doc. You can be a registered psychologist, which we'll talk about a little bit more. Again, the employee of an exempt setting. Again, the psych assistant. And again, the Department of Mental Health waiver. So what are the requirements for this supervised professional experience? Well, there are requirements for it. And just briefly, the registered psychologist, that means that you have your doctorate degree. You've already had those 1,500 pre-doc because it's only a postdoc thing. And this is when you're working at a community agency that gets 25% of funding from government sources. You can do this for the 2.5 years, but this isn't something you can renew. This really is meant to be your postdoc, not a forever situation. Supervised professional experience can be obtained in many or several ways, which we've explained. So it can be the internships, the exempts, the psych assistant. So all of those different things we named are ways that you can get it. What about the supervisor, though? The supervisor needs to have 6 hours of coursework every 2 years. And when for your hours to actually count, we've all been through this. Minimum of 10% of the total time worked each week, you must be supervised. 1 hour is direct face-to-face weekly, and you can only count 44 a week toward the SPE. Also, a requirement that you maintain a weekly written log with all sorts of information that needs to be signed by the supervisor. The primary supervisor has to be employed in the same work training and available 100% of the time. And that could be, by pager, but they need to be on call for you. They have to have a plan to protect the client. You can't get these hours if you're working under your social work degree. You can't get these hours if a supervisor is receiving payment from you. That's not supervised professional experience. And trainees must have no proprietary interest in the business. So let's move on to the next slide now that we're kind of talking a little bit more about supervision.
The notice to consumers says the Department of Consumer Affairs Board of Psychology receives and responds to questions and complaints regarding the practice of psychology. If you have questions or complaints, you may contact the board on the internet at or by emailing, or by calling, or by writing. And good luck if you are actually trying to get your license to get them to respond to you. No, just kidding. There's a few of them that are pretty good. So that's what you need to know about the board. So remember, they can deal with unprofessional conduct and illegal behavior. Remember the definitions of psych assistant, psychologist, and registered psychologist. Remember that it's about protecting the public. And remember that the board falls under the Department of Consumer Affairs because that does influence the questions as well. So what are the qualifications for licensure? To qualify for licensure as a psychologist in California, 4 criteria must be met. Can you name to yourself what those criteria are? Pretty easy to remember that you had to get your doctorate, isn't it? And as you probably remember, there was specific coursework that you had to document when you sent your application to the board. Can you remember? There are 5 categories. Can you remember what they are? Okay, so think there's 2 lie in the realm of abuse of other people. There's substance abuse, human sexuality, and aging and long-term care. So we've got coursework and the degree. What else do you need to do? This is pretty easy to remember because you have already completed your 3,000 hours of supervised experience. If you are taking the CPSE, at least 1 year has to be completed postdoctorally. I know someone named Kate who actually did all of her hours postdoc. She didn't do a pre-doc internship, but you cannot do all your hours pre-doc. So you can not do it that direction. And then of course the exams. 2 written. I don't really see how they're written, but they're multiple choice anyway. And the EPPP or the CPSE or the CPLEE. So those are them. Substance abuse. Can you guess how long coursework from each of these different classes has to be? Substance abuse, that has to be a whole semester, a quarter. And are there any others that have to be an entire quarter? No. The rest range between 7 to 15 hours. So 7, the shortest, is for child abuse. 10 for human sexuality and aging and long-term care, so kind of their own interesting topics. And then spousal or partner abuse is actually 15 hours, so it's interesting that that's 2 days of coursework versus child abuse. Can you think, maybe you want to think about some reasons why that would be the case, if you find that to be an intriguing question. So, doctorate degree. You can also have a doctorate. It doesn't just have to be psychology, your doctorate degree. It could be counseling psychology, educational psychology, or really anything that the board deems. So it'd be interesting to go research what are other doctorates that are deemed. I mean, there's the PsyD, the PhD. You need 2 years of supervised professional experience, and that you can only get 44 hours a week anyway, so there's really no way to do it, I don't think, in less than 2 years. So you've done your courses, all of that. You may not engage in the practice or represent yourself as a psychologist without a license. Those licensed in another state, this is interesting, can provide services in California for 30 days in any calendar year. So not like you come for a month, but there are 30 days in the year that you are allowed as a psychologist out of state to provide services. Very interesting. This, if you are licensed in another state and want to become licensed in California, the board understands that it can take time. So, if you pass the CPSE and at the time of application have been licensed for 5 years somewhere else, it could be another state or Canada. I don't think Europe necessarily. You can provide services for 180 days. So how many months would that be? Oh goodness, like half a year without actually having your application approved with the state, because they take a while and they know that. So you move here, you pass the CPSE, you can practice for 6 months and before you need to have the license. You have to have submitted your application though. Yeah. Okay, so that is on qualifications for licensure. Now we're getting into a pretty hefty topic, and that is that of supervised professional experience. Okay, so this, as of 2005, they made changes. So what do you want to know when you go into this exam in terms of supervised professional experience? There's a number of important things. You want to know the definition. You want to know what the requirements are. You want to know how you can obtain them. You know, how can you get those hours? So that's kind of what the intern has to do. What are some of the guidelines and requirements of that experience itself? What do these internships and psych assistantships have to have? So you need to know what that is in terms of an agreement, the requirements for how much supervision you get, the keeping of a log, and then things about the supervisor. So let's start with the definition. It's an organized program that consists of a planned, structured, and administered sequence of professionally supervised comprehensive training experiences. So basically, they're saying you can't just go see clients. There needs to be a sequence of training that's preparing you for independent practice. The requirements for an applicant, you need to do 2 years, 3,000 hours of qualifying applicants to be a licensed clinician, of qualifying experience prior, and a year is considered to be 1,500 hours. So, as said before, at least 1 year has to be postdoc, and they have to be completed within a 30-month period. So, if both years of the 3,000 hours are completed postdoc, they have to be completed within a 60-month period. The regulations do not limit the number of hours that can be accrued under a single supervisor. Thus, all 3,000 hours can be accrued under the same primary supervisor. So what are these different contexts? Well, we all know there's formal internships. They are by definition predoctoral, so only predoctoral hours can be accumulated at formal internship sites. That's like APA, APIC, KPIC. So that's interesting. They're just predoctoral. You can also be an employee in an exempt setting, and that could be pre or postdoc. And that's like a government facility or educational institution. Now, many of us are familiar with the psych assistant realm. And this is when you're employed by a licensed psychologist, board certified psychiatrist, a psychological corporation, or a psychology clinic. Okay. There are formal postdoc training programs, and of course in those, you can get your hours. It needs to either be APA accredited, a member of APIC, or a member of KPIC. And finally, in terms of different contexts, there's registered psychologist. Can you remember, we just talked about this, what kind of agency will qualify as, that you could work in as a registered psychologist? It is a nonprofit community agency that has a minimum of 25% from government funding. I'd be curious to learn more about why that is. I don't know. Okay, so here we go. We know what it is. We know how many hours you need and where you can get them. But let's hear a little bit more about what these programs and this experience is all about. So, first of all, you need a qualified supervisor. How do they define that? They say you need to have 6 hours of supervision coursework every 2 years. Every 2 years. Not every year, every 2 years. And hopefully you're pretty qualified because you have your license aside from that. But they want to know that you have some basic skills in terms of, not only skills, but, know the ethics, the law and ethics around that job. The supervisor and supervisee need to have an agreement. Can you think to yourself what needs to be in that agreement? And when does that agreement have to be made? And how does the board, in what way does the board know about it? So it needs to be made prior to starting the hours. It has to be prepared together. It needs to say specifically what they'll be doing. Are they an intern? Are they a psych assistant? It needs to say specifically when they're starting and when they think they'll end. What are their duties? What is the address? What are the goals? What are the objectives? It needs to lay it all out there, which is always a good idea in terms of most relationships, to be as clear as possible from the outset of expectations and boundaries. The primary supervisor is required to maintain the agreement until the hours are completed, and then has to submit both the agreement and a verification of experience signed by that supervisor. So here's something, though. For psych assistants, that agreement, at least the training program that you've written up with your supervisor, needs to be submitted and approved beforehand for the hours to count. That should be in here. Supervision requirements. So how much supervision do you need? You must be provided with supervision for a minimum of 10% of the total time you work each week. So if you work 44 hours, how many hours of supervision do you need? You need 4 hours and 4.4 hours, or yeah, hours then, of supervision. How many hours must be face-to-face and direct individual supervision with the primary supervisor? Just one. You cannot count more than 44 hours a week, FYI. What about a log? So you do not have to turn these logs in when you first submit your application, but you do need to keep a written weekly log of all your hours. It needs to have all sorts of information, like your work setting, what you did, what the dates are, how many hours, how much supervision did you get, was it face to face, was it group? So there's some standard forms you can get that will make sure that you're logging all of the appropriate things, and they need to have a place where you can have a signature. They also need to include, so this is interesting, and I don't know if this is just one statement at the end after everything is complete or if it's supposed to be signed weekly, but it needs to somehow be indicated that the primary supervisor is saying the information's accurate. So they're committing to that. They're not just not looking and signing something. They are saying, yes, I have read this. I know it's accurate. Or they filled it out themselves. So that's important. You could be audited. So the reason you want to keep those is not because you have to give them to them right when you apply, but they might ask for them, and it is a requirement that you have them. So if you don't, you could be in big doo-doo. What else about the supervisor? Generally, you need to be a licensed psychologist. And now, even though they said, oh, you can get all your hours from the same supervisor, that is true, except a psychological assistant can only accrue 750 of their hours under a board-certified psychiatrist. So, only if it's a psych assistant, only if it's a psychiatrist, does that 750 max apply. Supervisor's employment and availability. The supervisor needs to be employed in the same work setting and be available 100% of the time. That's true, 100%. There's no minimum number of hours a supervisor has to be employed, so they could really be, it could be 2 hours a week as long as they're still employed by the same person. And what does availability mean? Does that mean you need to be able to see them face to face whenever you want? No, it just means that you have access to them somehow, whether it's by cell phone or pager. Who has a pager anymore? I don't know, but maybe Sharon Jablon does. Crisis emergency plan. So what is that? The primary supervisors must ensure that a plan is in place to protect patients should a crisis or emergency occur while the supervisor is not there. Payment. So how does payment work? Can supervisors be paid for supervising? No, they cannot. Not by, no, not for a psych assistant. They cannot be paid. Now, they could be a supervisor if you were in a formal set. If you were in a agency, you can get paid to do your job. But I think what this is referring to is that supervision hour. The supervisee, the psych assistant, can't be saying, I pay you $100 for giving me supervision every week. What are other professional licenses that you can or can't work under? Can you work under someone with an LCSW? No. You need to work with someone who has the training training and the standards that you need to have as a licensed clinical psychologist. Apparently, board certified can do that for up to 750. Welfare of patients is something else to know about when it comes to supervised professional experience. It is this primary supervisor who is responsible ultimately, which means they are responsible for monitoring the work, the development, and ensure that their supervisees have the education and training that they need. But the supervisors have to have enough education and training to supervise them on something. So you can't be supervising a client who wants to do lots of trauma work and specialize in that if that's not your specialty, because then they're kind of out there on their own and you can't really know if they're performing adequately. you can't be responsible if it's a specialty you don't have. 5 more things. You want to know about complying with laws, delegated supervisors, letting patients know about the person being supervised, what the relationship is like, and then there's a funny little pamphlet that you need to know about. Compliance with laws. The supervisors must ensure that the supervisee always complies with laws and the ethics code. And this applies to both how they work with their clients as well as their records. Delegated supervisors. So the primary supervisors need to also monitor the delegated supervisors. Yes, you're delegating, but you are basically responsible for all things related to the training and practice of your supervisee. So whether that's their records or their relationship with their clients, or if the delegated supervisor is competent and they're getting competent supervision, it's all in your purview. Now, while we said that you cannot have an LCSW as your primary supervisor, you actually can have marriage and family therapists and educational psychologists, clinical social. You can have other folks be delegated supervisors. There are special requirements for delegated supervisors of psych assistants, though. So we're talking, when we talk about delegated supervisors and the kind of flexibility that there is, that is mostly in community settings or corporation. But with a psych assistantship, there are specific requirements that you want to be very clear on, and particularly with delegated supervision. Patient notification. So, do the patients need to know that they aren't seeing someone who's licensed? Yes. And who is responsible for that? Well, the primary supervisor is responsible for informing each patient prior to the rendering of services. The patients need to know the person's unlicensed, they're being supervised, and that person supervising them has full access to their treatment record, and that when fees aren't paid, that the supervisee, when fees are paid, that they're actually paid to the primary supervisor, not to the supervisee. This needs to occur in person by the supervisor, or it can be a written statement signed by the supervisor and given to the patient. So that's probably much more common practice than supervisors going in to meet with all of these clients. So it's really have a letter. But that's not something that you will always see actually happening in clinics. So as you kind of study, think, what have you actually seen in your experience and what have you not seen? And if you do want to go into supervision, what are some of these guidelines that you want to make a list of? I mean, you'll obviously need to really be rigorous and look at your materials, but what are some things that you want to make sure that you're doing to be practicing ethically? And if you want to be in compliance, you need to actually have a written statement that you sign that says, I'm the supervisor. Hello. And that doesn't often happen, but here it is. So you can break away from the mold and actually be in compliance with the legal and ethical standards here. The supervisor-supervisee relationship. Few things. You cannot have been their patient in therapy, and you cannot engage in sexual contact. Also, the supervisees can't have a proprietary interest in the supervisor's business. Granted, you're interested in building their business because you're employed by them, but that's different than having a proprietary interest. If you don't know what that word means, then look it up. And finally, I want you to ask yourself now the notice from the board, the notice to consumers from the Board of Psychology. How do the patients need to get that? Are they given it? Is it posted publicly? Is it something that you only have to give them if they ask specifically? Okay, the answer is it needs to be posted on your wall visibly. But there is another little pamphlet that all folks need to have. And that does not just apply now to the patients, but also to the supervisee. So, professional therapy never includes sex, that pamphlet. Not only are our patients supposed to see that, but primary supervisors must provide each supervisee with the pamphlet. Bet you didn't know that or get that. I have not ever seen that be a common practice. It does happen, but I've seen at different internship sites that it is something that not all supervisors know to do. Okay, that is just a little bit on supervision and supervised professional experience hours. Psychological assistants may be employed by licensed psychologists, board-certified psychiatrists, psychological corporations, and clinics, and they are able to perform limited functions. The licensed psychologist so the supervisor can have up to 3 at a time, and psychiatrists can only have 1. A clinic and corporation can have up to 10. To become a psych assistant, a person has to have at least a master's degree in psychology or education or its equivalent. And there's 4 issues we're going to talk about here in terms of the supervision, fees, getting your hours, and how to register. So in terms of supervising, your supervisor can't charge a fee for the supervision, you can't rent office space from them, you can't have interest in their business beyond being a part of it. If you're a registered, so that's for psych assistants, but if you're a registered psych assistant at a clinic, unlike in a private practice, you can have delegated supervision from someone who is not the primary supervisor, as long as they're employed in the same organization. But it needs to be a psychologist or a board-certified psychiatrist if you are a psych assistant. Fees, you cannot provide services for a fee, but they can pay your supervisor. And if you advertise, you have to note that you are supervised with your registration number and the name and license number of the supervisor. So that's kind of crazy. The supervised professional experience accrued in private practice settings. Now, this is important. If you want to do that, you have to prepare a plan together with that supervisor, and you need to submit it to the board and get approval prior to getting your hours. Otherwise, they don't count. In terms of registering, you have to register just like you do as a licensed clinical psychologist, and it has to be renewed annually on or before its expiration. At the time of the renewal, the supervisor must submit a report to the board describing the nature of the limited functions, the locations, all that same stuff. If a registration becomes delinquent due to non-payment of fees, you cannot practice during the period of delinquency. It becomes void if it's not renewed within 60 days after its expiration. So, when a psych assistant is terminated, the employer has to notify the board within 30 days. And that, effective October 23rd, you can only be a psych assistant for someone up to 6 years. So, let's talk about having that license and all of the things that go along with the actual licensing. You need to renew every 2 years as standard practice. Same with supervisors only needing their 6 hours of supervision training every 2 years. It expires at midnight on the last day of the licensee's birth month. So if you are a September baby, September 31st at midnight is when it expires. A license that has expired can be renewed anytime within 3 years. So you've got 3 years. After that, though, there's new things kind of kick in. You might you have to apply again and then either take the CPSE or CPLE. If you also hadn't even been a psychologist for 5 years, then it's going to be, so actually this has been in the past that it would be the CPSE, but they're getting rid of that, so this will change. But that's how it's been up until now. A licensed psychologist who's not practicing can apply to the board for an inactive status, and that's probably a good idea. So we're going to talk in terms of the license about a few primary things. 3, actually. First is what you need to do in terms of continuing education. And the second is what happens if you're from out of state. And the third is just very briefly about advertising. So to maintain this license, being a clinical psychologist means being a lifelong learner and really being up to date on the current standards in terms of law, ethical practice. This is a serious endeavor. And for that reason, you need to have 36 hours of continuing education every renewal cycle. And how long is a renewal cycle? It is 2 years. So 36 hours, it breaks down to 1.5 hours of continuing education per month. Not much, really. If your license is inactive, you're exempt. But to reactivate the license, you have to complete the 36 hours of continuing education, training in law and ethics, and any other mandatory courses for the 2-year period prior to establishing the license as active. So you need to get caught up. When a licensee renews the license for the first time after issuance, the psychologist is only required to accrue continuation education for the number of months the license was in effect. So basically, let's say I get licensed now or soon. It's good. I'll be up for renewal at the end of September, so I'm not going to actually the first time go a whole 2 years, which means that however many months, I'll multiply that by 1.5 to see how many hours of continuing education I actually needed, or CE credits. There's all sorts of ways of getting it. A few things to know. If it's something that's like internet or correspondence, not in person, only up to 27 hours can be accrued that way. So 27 hours. And might also want to know that the board is encouraging people to get coursework in geriatric psychopharm, AIDS, and diversity issues. So those are 3. As of 2007, you also must certify you've obtained some training in law and ethics. It doesn't matter if it's, an hour. It doesn't say how long, but some. And you need to make sure you're up to date on any changes in law and ethics as related to the practice of psychology. And then we've gone over this before, but what courses prior to January of 2004 were not required, and now if you get renew your license, you have to make sure you've taken it. That would be spousal abuse and aging in long-term care. However, if you're just getting these credits and you started before 2004, it's actually just 1 hour of partner abuse or 3 hours of aging care that you need. In terms of accreditation of these CE credits, it needs to either be through the APA, CME, which is continuing medical education, so that's cool, but they have to be applicable directly to psychology. And then CPA, which is the California Psychological Association. And with the medical ones, the board has to approve it, but I think you can figure that out in the course description, probably. It's only 2 years ago that we are not required to submit proof of these credits, which is really nice in a way. I think the board is overwhelmed with work, so instead they're relying on the random audit to keep us in line. So you can be randomly audited on your credits for 4 years after the renewal period. So kind of 2 rounds. You need to always have your records from 2 rounds back. And then, as said before, the primary supervisors need those 6 hours of coursework every cycle. Okay, I said I was going to talk about the psychologist out of state and advertising. So out of state, you can provide services for up to 30 days in the calendar year. Very cool. Or Canada. If you are moving and you have 180 days, calendar days, from either submitting the application or beginning residency. And if you've been licensed for 5 years in another state, then you don't have to take the EPPP or CPSE. You just need to take the CPLEE. In terms of advertising, you can't false advertise or misleading. It's illegal. That's not surprising. advertising, and that's good. Is it a felony or a misdemeanor? It is a misdemeanor. Now, can one be put in jail for misdemeanors? Yes, you can. And in this particular case, the law says up to 6 months. And the fine can be at the most what? 2,500. You can have either or both. And the board can also pursue disciplinary action against you, which gets us into talking about disciplinary action. So, disciplinary action. There's both non-disciplinary and disciplinary when we're dealing with unprofessional conduct. So, the board can do a whole host of things if you've been guilty of unprofessional conduct, including not renewing your license, not issuing you your license, and maybe even suspending or revoking it. Minor violations are usually non-disciplinary. More serious are also referred for formal investigation. And if the investigation finds support, it will be submitted to the Attorney General. So they're not staying so separate from the law that if something serious happens, you're not also going to deal with the law. You will. Non-disciplinary. So here's the question. Is non-disciplinary and or disciplinary actions confidential from the public? Is it the same for both of them? No, it's not the same. For non-disciplinary, it's confidential, and for formal disciplinary, it is public information. One thing that if there's a citation and fine, even if it's non-disciplinary, that will be on the record, unfortunately. So what are examples of non-disciplinary and disciplinary actions? Non-disciplinary, mediation. If there's no clear violation of law, but it's more a misunderstanding, like billing or something. Education letter. Okay, there's no harm here, but there is a departure in the standard of care, so the board will say, okay, here's what the complaint is, and here's what the behavior change you need to make is. A letter of warning. So this is when a minor infraction's happened. There's no harm yet, but it maybe seems significant enough that if the situation happens again, you're going to have formal action against you. So that would be something like you didn't put your license number on an advertisement. So it's a little bit less minor. Maybe it's a little bit more than an education letter. Educational review. Educational review is voluntary. If the board has a serious concern about you as a licensee or someone, or there was actually a significant violation, but there's not sufficient grounds to forward the case to the Attorney General, then what you can do is you can meet with the investigator, expert, or staff and discuss these issues of concern in a forum. Final non-disciplinary action, this is the one that's public, is a citation and a fine. Start thinking about the range for non-disciplinary, not for disciplinary, non-disciplinary. So these are used for less serious violations like false advertising, and the fine can be from $100 to $2,500 per violation. It's, but it's not considered disciplinary, and I think when it comes to disciplinary, you're getting outside of the realm of citation and fine. You're getting into more serious matters. If it's disciplinary, and this is what then becomes public, you may receive a letter of reprimand. There may be a 2-step agreement. There may be probation, suspension, surrender of license, or revocation. So, let's go over those. A letter of reprimand, this is when the violation wasn't so severe, there wasn't harm, but the letter is describing the improper behavior and can mandate things like coursework or cost recovery to the board for the investigation they put in to it. So, there probably wasn't significant harm if you go this route. The 2-step agreement. So that's an option again if it's not too severe and no harm occurred. Like, let's say they inappropriately coded a bill to an insurance company. So this is a case where you need to do remedial coursework, and maybe you'll have a billing monitor over your practice for a specified. So they really want to fix the problem, but it's serious enough that it's disciplinary, It's a serious enough violation, even if there's not harm, that things really need to be done to make sure you get it. Not just a letter like, hey, you got to put your license number on a advertisement. And then once you meet these conditions, the accusation is actually withdrawn. So that's great if, if it's a good fit. Probation, suspension, surrender, and revocation. Now, these are all in the realm of you don't have an active license anymore. So technically, before a licensee is on probation, you've had a revoked license, but it's been stayed. So what that means is they put the revocation on hold. They didn't actually revoke it. So then you have a probationary period, and in that time, if you violate the terms and conditions that were set, you then really will perhaps have your license revoked. Violations that result in this are things like gross negligence, repeated negligent acts, commission of any dishonest, corrupt, or fraudulent act. So these are bigger deals. Suspension is when you cannot practice, you cannot say that you're a psychologist. And this is something that would happen when, like, if you are convicted of felony and go to jail, you cannot say that you're a psychologist in jail. An interim suspension order requires the licensee immediately suspend the practice. And this is issued when they have been, there's a serious violation going on. So they're either in violation of the Business and Professions Code, or they've been convicted of a crime that's substantially related to their license validity. That's the first piece. The second necessary piece is that continuing to practice would represent a danger to public health, safety, or welfare. So it has to be both of these. Now, surrendering of license. Rather than completing an administrative hearing, a licensee can just opt to surrender. So if you have a psychologist who, they may even still be, they probably are still facing the Attorney General and other such things, but let's say they have been responsible for serious sexual misconduct with lots of clients, they're probably just going to surrender their license because they're not going to win that. They're not going to win that, and dragging it out and going through it would actually be worse for them. Well, who knows, but they probably would not want that as much. Revocation, that's what you would consider second. Surrendering is one thing, but in terms of what the board is taking action on, this is the most serious. You have lost your license. If it's been revoked, you've lost it. And then this would be things like a therapist is found guilty of sexual contact within 2 years of termination of treatment. That is automatic. That's just automatic. And the judge cannot stay the revocation. So there's other areas where the judge might say, let's actually make this a probation. But that's a requirement. So what's your recourse if you have been subject to disciplinary action? You can petition for reinstatement, or you could petition to modify the minimum. You can modify it, the disciplinary action, but usually there's a certain amount of time that has to pass to do that. So, in order to petition, if you had your license revoked, suspended, or surrendered, and you want to petition for reinstatement, you need to wait at least 3 years. Now, if you want to have an early termination of a probation that is going on for 3 or more years, then you have to wait 2 years. And if you want to modify a condition of a probation, you need to wait at least 1 year for an early termination of probation. So let's say you have 2-year probation, then you have to wait 1. So the board can require that person, they are within their rights to require you to have more training or pass an exam. So they can say, okay, fine, but you need to do this CPLEE. And they can also, just to be very clear, they can deny licensure because of mental illness and chemical dependency issues. It's a matter of safety for the public. And if you have applied for licensure and been denied, you need to wait another year before you can reapply. So that's an important thing to remember, the 1 year to reapply if you've been denied. And what do you think? Do you think someone who's registered as a sex offender could ever be eligible for licensure or registration? The answer that you and I and everyone on earth would probably know would be no, they absolutely cannot. Time frame. The time frame for filing accusations against a licensee is 3 years from the date the board discovered the act that is the basis for the action. So, if I want to file a complaint against a psychologist who I don't know was overcharging, I don't know. They probably wouldn't get in trouble. But anyway, I could only do that within 3 years of them the board finding out. Now, if the board never found out, then I've got 7 years since it first happened. So whatever comes first. 2 more quick things.
So the only legal requirement to really know about is that for telehealth, which is when it's delivered via technology, there needs to be verbal consent, and you need to document that.
We're going to talk about the ethical violations and complaints. So you can see these are members of the board. We're going to hear about ethical violations and complaints.
Okay, so the ethics committee and ethics complaints, we'll talk about that, and we'll talk about ethical violations by colleagues. The first standard of the ethics code says within 106 is that as a psychologist, you are required to cooperate with the ethics committee. Any affiliated state, in fact. If you fail to cooperate, that is in itself an ethics violation. If you're a member of the APA, it can be handled by the ethics committee or the licensing board or the courts. Violations of non-members are not within APA's jurisdiction, but can be for others. Upon conclusion of an investigation of a complaint, the ethics committee will dismiss the case or recommend one of the following actions. You can do reprimand, censure, expulsion, stipulated resignation, are the different outcomes. So reprimand, that's like something, yeah, it was an ethics violation, but didn't really cause too much harm to the profession or another person. So that's like not putting your license number in your business card, probably. Censure is if there's a violation that was of a kind that really was likely to cause harm, but not substantial. And it didn't kind of hurt there wasn't a gravity to it hurting the profession to warrant something more severe. So maybe you had a client you didn't like and you didn't do pre-termination counseling or something like that. Certainly could have caused harm. So it's a violation, but you didn't hurt the whole profession in any sort of major way, and the person is okay. But expulsion, however, this is something that could cause substantial harm to another person and requires gravity. Finally, a stipulated resignation is something that can be offered if they find that the respondent, yes, they did commit a violation, and failed to show good cause why they should not be expelled, contingent on execution of an acceptable affidavit and approval by the board of directors. So, non-disciplinary actions for minor violations remain confidential, except for the citation and fine. And so what would those be? Mediation, educational letter of warning, education review, citation, fine. Okay, so the citation, fine, public. Now the disciplinary actions. Let's talk a little bit more about what that actually looks like. These, if they're more serious, they are referred as well for formal investigation. If there's support for whatever allegations were made, the board will submit themselves the case to the Attorney General. What kinds of disciplinary actions does the board itself take? A letter of reprimand for minor things, no harm happened. A two-step agreement for minor violations could happen. So you need to fix your business card or what have you. You could, and then there can, if there's some real negligence, that's when you have more serious things that happen, like probation, revocation stayed, such things. What about suspension? This is when you cannot practice. For example, you were convicted of a felony, um, or you need to immediately suspend your practice. Surrender of license, the licensee just says, you know what, I'm out. They don't want to complete the whole hearing, so they can just surrender it. Revocation, though, is when the license is actually lost, and that guilty of sexual misconduct, you can see that that would happen. What is your recourse? Well, you can petition for reinstatement or modification of the probation. At least 3 years for reinstatement of a license, revoked, suspended, or surrendered. At least 2 years for early termination of probation or of 3 years or more. And finally, at least 1 year for early termination of probation of less than 3 years. So, yeah, you can say, hey, board, please, I've made amends. Please modify this. If, the person's, you have to wait. So basically it's saying, if it was revoked, you need to wait 3 years before it can even be considered. If you were, if it was early termination of probation of 3 years or more, then you still have 2 years before you can modify that. Then 1 year for early. Okay. So time frame. Accusations must be filed within 3 years from the date the board discovers the alleged act, or within 7 years from the date the act occurred, whichever occurs first.